Yeah.
Cut the music.
It's on now. There we go. The music was great. This group always amazes me how quickly you quiet down and get ready to for the meeting. Okay. Call the Florida Housing Finance Corporation Board of Directors meeting of June 21st to order. And Sheila, if you...
Sorry.
That's all right.
I apologize. I have lost my list. Okay, I'm going to have to do it from memory because I don't have my list with me. I apologize. Latasha Green Cobb.
Present.
Ron Lieberman.
Here.
Ray Dubuque.
Here.
Mario Ficella.
Here.
Creston Leifried.
Here.
Renier Diaz de la Portilla.
We have a quorum.
Yeah, we do, but I don't. I now have to come up with the rest of the
Barney Smith.
Barney, Natasha,
And Ken Lawson.
and Ken Lawson. My apologies.
It's okay.
Thank you. All right. Before we get into the minutes and all, are there any consent agenda items that anyone would like pulled and put on action committee? All right.
Mr. Chairman, I have not received any.
Okay, great. All right, with that, you should have previously received a copy of the minutes. Do I have a motion to approve the minutes?
Motion to approve the minutes. Second.
We have a motion and a second. Is there any discussion on the minutes? Seeing none, all in favor? Aye.
Aye.
Any opposed? Okay. All right, public comment. Again, these are for items other than legal, because legal's a little bit different in that we'll address those as we get to those items if there are comments on those. That anyone like to make about something on the agenda? Okay, seeing none. Audit Committee, Ron?
Yes, Mr. Chairman, we should have a copy of the Florida Housing Finance Corporation audit results.
Ron, could you turn on your mic, please? Thank you.
Okay. We should have all the board members, we should have a copy of the Florida Housing Finance Corporation audit results in front of you. Okay, the audit committee met yesterday, June 20th, and heard from Ernst & Young regarding the outcome of their audit of the 2018 financial statements prepared by management. The Ernst & Young audit resulted in an unmodified option on the 2018 financial statements, and there were no management comments from the auditors. The audit committee recommends that the board accept the audit for 2018 financial statement, and Mr. Chairman, I would make that motion.
Okay, we have a motion to accept the Audit Committee report. Do I have a second?
Second.
I have a second. Any discussion on it? All right, seeing none, all in favor?
Aye.
Any opposed? Okay. All right, Angie?
Good morning. So the purpose of this item is to allocate funds from the 2019-2020 state budget and other available funds. The first part relates to appropriated dock stamps from the State Housing Trust Fund. The legislature appropriated a total of $200.6 million for Florida Housing's programs and directed the use of just under $173.5 million of that in proviso language, including $115 million for hurricane recovery. The remaining amount, just over $27.1 million, is available for allocation by the board. The final amount may change slightly if the governor vetoes any of the existing proviso language. The second part is to allocate funds in the guarantee program that have become available after the recent refinancing of a development out of that program, and a portion of unrestricted net position that we are recommending that be allocated to sale and to sale workforce housing. In addition to the recommended allocations, we anticipate that approximately $50 million in sale program income will be available for the upcoming RFA cycle, bringing the total available sale funds close to the amount used in the previous RFA funding cycle. There is approximately $4 million remaining in the 2018 sale workforce funding. With the recommended allocation of additional funds, Florida Housing would be able to fund 3 workforce developments in the next cycle, one expected to be in the Florida Keys, and 2 others in areas of the state with a high level of need for these units. Any remaining funding from such an RFA, as well as any program income received from these developments, would be designated as sale. So staff recommends that you approve the allocation of the fiscal year 2019-2020 discretionary appropriation from the State Housing Trust Fund as follows. For the Florida Housing Data Clearinghouse, up to $315,000, with any funds not used for the data clearinghouse going to the sale program. For the sale program, $26,821,000, or the remaining appropriation available after funding the data clearinghouse. Staff further recommends that you approve the reallocation of $5 million in the guarantee program funds to the sale program and approve the allocation of unrestricted net position as follows: $20 million to sale and $15 million to sale workforce housing.
Okay, we have a recommendation from staff. Do I have a motion?
So moved.
Have a second? Have a motion and a second. Discussion?
Just-
Yes, Ron.
Just briefly, when Schimberg does their study, they look at past history. We really don't do anything to look at trends or job creation or anything like that, to project what, needs may be in the future. So I'm just curious, and I know that's difficult to do. I'm just curious, do we do anything to look at, possible future needs?
So we actually, is this,
Yeah.
it is on. Good morning. The Schimberg Center does look out into the future, and particularly does that for local governments, because local governments have to do future population projections, household housing, et cetera. So what the Schimberg Center has not done with the information that we use is it has not projected job growth. And that is something that we haven't sort of known how to do that. That tends to be done sort of better at the local level. And there isn't a good way to kind of aggregate that up, I guess you could say, to the state level. So we certainly do look back, but we use that to sort of forecast forward, I guess you would say. And from my point of view, the numbers that we use, I think some forward-looking makes some sense for us, 5, maybe 10 years out. Local governments actually will look out further, 20 years and such. But we haven't figured out how to do that related to jobs. Florida Housing hasn't. I don't mean it's not done out there.
But then certainly would, look at future needs, based on, jobs to me would be the ideal, situation to determine future needs, but.
I do think that population projections do take some of that into consideration. I think it's part of a broader set of projections that the Bureau of Economic and Business,
Demographic research.
thank you,
Who's meeting across the hall?
Beaver at University of Florida does, that incorporates some of that, but you don't see the job calculations by themselves.
Thanks.
Okay, any other questions?
I have one. On page 1 here, where it breaks down the trust fund allocations, do we have any input into this? I mean, I'm just looking at the numbers and, specifically one line item under local government is the veterans housing, which seems, extremely low to me. I don't know if we have any input in that.
Mr. Chairman.
Yes.
So, Mario, under the present situation where those budget line items are, that's actually, so those were placed in the state budget by the Florida legislature. The rental, I'm sorry, the specific one that you asked about, grants for veteran housing, 1 million, that actually will come to us, and David Westcott's direction will be, that'll be new for us. In the past, in the recent past, that has been a line item that has gone to a specific nonprofit. The legislature decided to allocate that money to Florida Housing to competitively bid out how that $1 million or who that $1 million would be essentially granted. So we're in the process of doing that, assuming, and I don't think this will happen, the governor signs the budget, which he has not done yet, and this is in the budget. But I think it will stay. I don't think he'll move that out. One other thing of note is, as I mentioned, the governor has not signed the budget yet. This is fairly late in the fiscal year, which starts July 1st. The governor may sign the budget today. That's possible, but unlikely. We think that will happen next week.
Okay, thank you. Any other questions? Okay, we have a motion and a second. All in favor? Aye. Any opposed? Okay, thank you.
Thank you.
All right, Nancy?
Good morning again.
Morning.
This is the Hurricane Housing Recovery Program, proposed allocation. At the last board meeting, you gave staff the authorization to begin implementation of the Hurricane Housing Recovery Program, HHRP. This is the SHIP-like program with $65 million appropriated by the legislature to go to Hurricane Michael counties. This program, as Trey indicated, is pending the state budget being signed by the governor, which has to occur by the end of this month. You've got a colorized version of Exhibit A, which I see some of you have on your desk, that shows you the proposed allocation between the 11 hardest hit counties and 2 associated cities, the city of Tallahassee and Panama City, that currently administer SHIP funds in those counties. So we held a public workshop on Tuesday. It was well attended, mainly with local SHIP administrators, to discuss our proposed approach to program implementation, which would be very similar to the way we implemented it when the legislature provided funds back in the mid-2000s. Once the funding agreement is executed with each local government, they will be eligible to receive a disbursement of HHRP funds, pending the funds being available to Florida Housing. And as with all of our trust fund appropriations, we anticipate the first disbursement of funds will be available no earlier than October 2019. That's just based on the flow of doc stamps into the trust funds. But this gives the locals time to rework any strategies that they might want to implement that are outside their already existing local housing assistance plans, and work with their elected officials to get these funding agreements signed. And we're very hopeful, of course, that the governor will sign the legislation. So our recommendation to you is that you approve the proposed allocation of HHRP funds to the eligible local governments as detailed in Exhibit A.
Okay, thank you. Do I have a motion?
So moved.
A motion and a second. Discussion?
I have a question.
Yeah.
Where it says, I'm reading here, funding agreements will detail all program requirements for administering the funds. Many of the program requirements will mirror similar requirements for the SHIP program. So they're going to make adjustments to what they've already said on, what percentage is going to be for rehab, percentage for new single family, that kind of thing?
Yes. So the funding agreement, so Florida Housing has created a template funding agreement that would be the same for every local government. And there will be some exhibits then that will be specialized, customized for each local government then based on the specifics of what they're going to do in their areas. So just as we have done for many years with disaster recovery SHIP dollars, a local government can use what's in its local housing assistance plan, and typically they'll have a disaster recovery strategy in there too, just to cover the bases in case. And in this case, because this is more money than whatever small amount you'd get with that total of 5 million that we can allocate when the need arises, there may be some more specialized things they want to do here to spend those monies. So they would have to detail those in one of those exhibits. They'd have to tell us which of the strategies in your assistance plan are you going to use? Do you have any new ones? Are you going to reprioritize your dollars in some kind of way? And all of those proposals, they'll have to go through the same public process, or basically the same public process as they have to with their LHAPs, their big ship LHAPs now.
Okay.
So it'll be real plain for the public, for Florida Housing, for interested parties to see.
So what they did in most SHIP plans is they said this percentage is going to go to, single family, this
Yes.
is going to go to.
They're going to have to tell us that,
Okay.
yes.
Okay, other questions?
I have a question.
Yes.
Nancy, could you explain why we didn't award anything to Taylor?
The need, basically.
Okay.
When we went through, the allocation process, or the data, the first thing we did for the allocation was we reviewed the FEMA data. And over again, for Leon County, as an example, in a sense, didn't have a lot of damage overall, but Leon County is a big enough county so that the little damage Leon had, there were quite a few homes that were actually impacted. Taylor didn't even request SHIP disaster recovery funds from us. That's how limited Taylor County's damage was. So if you look at the data in Exhibit A, what you'll see is that the total number of units damaged, according to FEMA data, which is the best we have that's consistent across, or we hope is consistent across the counties, was 74 homes, ultimately. So when we ran this, and we ran this in some different ways as we were working towards, setting this up, it looked to us like the damage was just so limited that it didn't make sense.
Okay, so, may I have?
Yes. good.
So I guess my concern is that even if it is limited, the reality is there is some damage. So I personally would have liked to see something go towards them. I understand that it may not have been as large as the others, but there was damage, and depending on who those individuals were within those 74 homes, they may not be able to do anything without some assistance. Just because the government didn't request doesn't mean that the homeowner doesn't need assistance. So that would be my thought process.
Okay, thank you. Obviously, we're not going to get 65 million just dumped on us in October. It's going to be somewhat of a smaller amount. How do you then divvy that up between the counties that are here? I guess on what basis do you start?
Right, and to add to that complexity is the regular SHIP disbursement. So whatever doc stamps become available in October, or by October, they're gonna start trickling in before that, but typically the amount is so small that getting it out is, you're getting a few dollars out. So one of the things that we agreed we have to go through is, and we haven't figured this out yet, I guess that's the bottom line answer, is where do we start with the regular SHIP communities versus this? Now, we would generally, I will say we will prioritize this funding over the regular SHIP funding, but typically what we do with regular SHIP funding, and I believe we would do something similar here, is remember that every local government, with SHIP funding, every local government gets a minimum of $350,000, assuming the appropriation is big enough, and in this year, the regular SHIP is. So I believe it's fair to say that we would disperse a smaller amount to every local government in the Hurricane Michael allocation as a starting point. So everybody's got some preliminary funds. The other thing we'll do to make this decision, Ray, is we will evaluate what funds they still have from SHIP that they can be using, and many of them are using, to help us sort of tailor that a little bit. So I think it's fair to say that the regular SHIP disbursement will have to wait a little bit, because this is obviously the priority. So I know that wasn't real specific, but that's kind of how we start thinking about that.
It helps. Thanks.
Okay, good.
Any other questions? Okay, seeing none, we have a motion and a second. All in favor? Aye. Any opposed? All right, great. Thank you, Nancy.
Thank you.
All right, Mr. Brown.
Everybody, you start laughing, I haven't even said anything. Just a funny guy. Hey, good morning.
Morning.
We've got quite a legal agenda for you this morning, so in the words of, to paraphrase the late Betty Davis, fasten your seatbelts, it's going to be a bumpy morning. Our first item for you today is the case of Ambar Riverview versus Florida Housing and intervener Las Brisas Trace, case number 2019-014 BP. This case arises from RFA 2018-111. That's the housing credit RFA for the 6 largest counties outside of Miami-Dade. Preliminary scoring and ranking resulted in the selection of Lucida Apartments, Las Brisas Trace, and Cannery Row at Redlands Crossing as selected funded applications. 4 unfunded applicants filed protests against these scoring and ranking results. All 4 protests were consolidated and referred to the Division of Administrative Hearings. After that, 3 of the 4 petitioners dropped their cases before the hearing, leaving Ambar as the only remaining petitioner. Ambar also dropped several of the issues that they raised, leaving only 2 issues for the hearing. The issue of Las Brisas principal disclosure form, and also their alleged failure to answer an application question regarding the involvement of a public housing authority. After the hearing, the judge issued the recommended order for your consideration this morning. The judge recommends that the original scoring and ranking be found correct, that the petitions be dismissed, and that funding continue to be awarded to Las Brisas, Lucida, and Cannery Row. Ambar has filed exceptions to this recommended order, to which Las Brisas and Florida Housing have responded. Both parties are present and would like to address the board. Staff recommendation is to reject all the exceptions and to issue a final order adopting the recommended order without changes.
Okay, thank you. Do I have a motion?
So moved. Second.
I have a motion and a second. Okay, any board questions before we hear from the,
I'll reserve my
people.
questions till after the presentation.
okay, great. I understand someone is here that would like to speak to this. Just to let the speakers know, I do learn from previous meetings. I have a timer, and I think that.
He's not afraid to use it.
Sheila's going to take care of it? Well, you give me sooner, because I like telling them to be quiet, so it's over. Go ahead. 5 minutes. And looking for your glasses counts, so go ahead.
Good morning. My name's Steve Moore. I'm here on behalf of the challenger, Ambar Riverview Limited. You've all received our exceptions provided by our attorney, and instead of having our attorney come up and talk, thought it would be better to hear our arguments in kind of a plain, simple English way, and from someone who's been participating in these programs for a long time and really is known for not being very litigious. In this case, Las Brisas did not correctly complete the principal disclosure form, which was a clear scoring requirement in the RFA. Since they did not complete the form correctly, they should not have been awarded 5 points. So what are the requirements in the RFA to complete the form correctly? The form itself states, quote unquote, if an entity or natural person serves in the capacity of multiple principals, each instance must be listed separately. What does that mean? So Steve Moore, if I'm an officer, director, and shareholder, that requirement says Steve Moore has to be listed 3 times as an officer, director, and shareholder. We did that. Here's all the other applicants in the RFA, as I reviewed it, did that. But there's even more requirements. There are 21 pages of instructions and examples of how to complete this form correctly. I've never seen that before. It's almost as many pages as RFA. So, in those examples and instructions show you have to list the principal multiple times in each role. There was a frequently asked question, and I'm going to read the question. If a person has multiple roles within the org structure, must they be listed multiple times, once for each role? The answer: for a corporation, if a person serves multiple roles, they may be listed once with the other roles identified next to the name of the individual. For example, John Smith serves as both an officer and a director for APC Inc. You may choose the option of director in the drop-down menu and enter officer after his name as follows. And there's an example that says John Smith, officer. I think everyone sitting here would agree that by these requirements, to complete the form correctly, an applicant either had to list the person multiple times for each position he or she held, or list them in one position and identify in parentheses by his or her name the other positions. Las Brisas did neither. Your staff conceded that Las Brisas did neither. Therefore, the form is not correct as of the application deadline, very clear and simple. I'm perplexed how anyone can make the argument that an applicant could do neither of the above and the form still be correct. However, your staff is taking the position that the intent of their answer to the frequently asked question was to remove the requirement to provide each principal's role. Again, by the clear reading of staff's answer to the frequently asked question, the applicant had to list the principal in one role and put all other roles in parentheses. If staff wanted to remove the requirement to list each principal in all his or her roles, then the answer to the frequently asked question should have been no, and the requirement should have been removed from the form, and the 21 pages of instructions and examples should have been removed. Simple and clear. It's very dangerous for staff to determine post-RFA scoring that a clear requirement did not match their intent, so that requirement does not need to be answered correctly or completely. This is a very competitive and stressful system on all the applicants, which is a good thing. So the plain reading of a scoring requirement must be upheld strictly, or an applicant will never know what is required or not required. This approach will substantially hinder the integrity of the system that has existed for years and lead to the old days potentially of massive litigation and 3-hour board meetings. Staff has argued that even if the form is not correct, that the roles of the principals can be found elsewhere in the application. However, the 5 points is based on the form being correct as of the application deadline, the form itself being correct. The 5 points is not based on finding the roles of the principals somewhere in the application to receive the 5 points. The form was obviously not correct as of the application deadline, so the fact that the roles could be found later or elsewhere in the application is moot regarding the 5 points. Staff has also argued that if the form is not correct, that it can be waived as a minor irregularity. There is clear and unambiguous requirement, which we just went over, as to correctly completing the form for the 5 points, with more guidance than I've ever seen on any requirement. To say that the correct completion of the form is not material flies in the face of all the guidance. How would an applicant ever know what's required to get points if you don't have to follow the clear requirements of the RFA? I would say practically this isn't a big issue.
You about to wrap it up?
But we guys have the system.
Is that
In closing,
is that your timer going off?
is it timer?
Okay, yeah.
Sorry.
Yeah, everybody else silence your phones, please, if you don't have them on silent. I wouldn't want them to
Phone's ringing.
confuse the timer with a cell phone ringing.
All right, I respectfully
Thanks.
request that you uphold the integrity of our system and vote to overturn the recommended order, which would disallow the 5 points awarded to Las Brisas. Thank you.
Thank you, Mr. Moore. Would you, oh, we have someone else going to rebut. Come on up.
So this will be our turn.
Yeah. Do we want to hear from the other person first, or?
I'll go next if
They're
that's,
go next, okay.
if
go
that's
ahead.
fine with the board.
That's fine, go ahead.
Good morning. Betty Zackham for Florida Housing. First, I'd like to talk about what this case is not about. This case is not about Las Brisas failing to disclose its principals. There's no allegation that Las Brisas is trying to hide anyone. They did not omit a principal from their principal disclosure form. The sole allegation is that they did not include the multiple roles about how their principals qualified as a principal. All entities were disclosed in the Las Brisas application down to the natural person, as is required by our rule. Florida Housing had all the necessary information it needed to score and rank the Las Brisas application according to the terms of the RFA. This case is also not about ambiguous language in the RFA. The RFA requires disclosure of principals. There is guidance that Florida Housing has issued that is linked within the RFA about principals disclosure. And that guidance had been updated in 2018, and that was the FAQ, or frequently asked questions, that Mr. Moore quoted. That language was permissive. Must you disclose the multiple roles of the principal? And if you listened, it said you may. I can go and find that, but Mr. Moore read it to you, and it was you may do this. That information that Ambar complains was not in the form is contained within the four corners of the Las Brisas application. We're not here about information that is entirely missing from an application. It's the location of the information that Ambar appears to have issue with. Now, the administrative law judge, he heard the testimony. He reviewed the evidence. He listened to arguments from legal counsel, and he found Florida Housing's action in funding Las Brisas reasonable and correct. And in fact, he found, in referring to testimony from Florida Housing's Director of Multifamily Allocations, Ms. Marissa Button, the judge found, and I quote, Ms. Button persuasively and credibly testified that Las Brisas Principal's disclosure form did not contain any errors and was complete. Even if one were to take the view that Las Brisas not disclosing the multiple roles of its principals in its principal's disclosure form is somehow an error, it's a minor irregularity at most, because all that information was contained within the four corners of the application. Florida Housing has consistently held and waived minor irregularities where the information is contained within the application itself. Last year, we had a case, it was Liberty Square Phase 2. Liberty Square challenged another applicant, Woodland Grove, because they failed to include a dash in front of a longitude coordinate. However, without that dash, the longitude coordinate would have been in India. With the dash, it was in Miami-Dade. Throughout the rest of that Woodland Grove application, it consistently said that the development was in Miami-Dade. Florida Housing waived that missing dash as a minor irregularity because all the information in the application was there. The same result should occur here. To be clear, there's no missing information in the Las Brisas application. There's no competitive advantage gained by Las Brisas. There's no uncertainty that the terms of the RFA were met. There's no adverse impact to Florida Housing, and there's no adverse impact to the public. The findings of fact by the administrative law judge are supported by competent substantial evidence. The conclusions of law by the administrative law judge are reasonable and are supported by the competent substantial evidence. And I respectfully request that this board adopt the recommended order as the final order of Florida Housing.
Okay, thank you. Someone else wanted to speak also, so.
Thank you. I won't take all 5 minutes. I'm Sean Frazier on behalf of Las Brisas. Ms. Atkins correctly stated the standards of review. I just want to point out one more fact identified by the judge in his recommended order. You've heard the 2018 frequently asked questions that Ms. Atkins confirmed were permissive in their instruction. You may disclose your principals this way. In 2016, that same question was asked. Must we disclose our principals and all of their roles on the form? And the answer was yes. A change was made by staff in the 2018 frequently asked questions to make sure that this would not become a gotcha provision, a means to kick out a competitor for really no competitive advantage. I'll just emphasize one more standard. I know you all know this. Competent substantial evidence is replete within the record. You have excellent staff, great witnesses. They looked at this bid carefully and made the correct decision. The judge looked in the eye, judged their credibility, and agreed they made the right conclusions. We suggest that you should as well and deny the exceptions.
Thank you, sir.
Thank you.
Okay, that's all the people to testify or to state their position. I guess it's not testimony, but, okay. Renier, did you have a question?
Yes, I have a question. It will probably be to Mr. Donaldson or the attorney, whoever's the attorney for
It's Mr. Donaldson.
Yes, it's a legal question, so, and the judge, not that I want him to come up here, but I don't have a choice, you know?
You will have to come to a mic, though, if you're going to answer and state who you are.
It's basically about what the administrative law judge said, that you relied on the HTJ Village View decision versus Florida Housing and Blue Broadway LLC. What is your position on those two? You believe these were precedents that favor your selection in this process? And the judge seemed to disagree with you on that. What is your position on that? And why do you think these cases are precedential?
Mr. Chair, members of the board, Michael Donaldson for the record, counsel for AMBAR. Two answers to the question. First, why did the judge not side with those? I mean, I could be flippant about it and basically say that an administrative law judge, when in doubt, is always going to defer to Florida Housing, which I would argue that's what he did here. Why did those two cases apply? Those are the two cases recently that dealt with the principal disclosure. Now, I will tell you with all candor, what happened in those two cases is the applicant did not disclose all of the principals. And because of that, they were found ineligible and they lost 5 points. The way that your RFA is set up, and Mr. Moore talked about the 21 pages of guidance, you know, that's part of the RFA. And it basically says you can do this one of two ways. 20 pages says you're supposed to list all your principals. 1 page says, in lieu of listing all the principals, you may list them one time and then put in parentheses what their positions are. That's what the question and answer tells you. It doesn't give you an out, which is what we say Las Brisas did here. So, to your question, why do I think those cases control? Those cases were principal issues. There's no distinction between listing all of your representatives or principals and identifying them. That's what is being drawn here in terms of a distinction is, oh, well, those cases, the principals weren't all listed, and they weren't. But the RFA doesn't make a distinction between listing them all and identifying all the roles. It's the same thing. That's why you get the 5 points. Here, there seems to be a merging of, well, you can find that elsewhere in the application, but you couldn't find that in the advanced review process because that stuff's not required. So to say now that you can fix the problem by looking at something that the reviewer in the advanced review process never saw, there's a problem there. Most importantly, in those cases, the judge didn't rely on Florida Housing's intent. He or she relied on the language of the RFA. That's what we say should have been done here. And instead, what we're relying on is Florida Housing's intent of what that language meant. Hopefully that answers your question.
Yeah, I am interested in the issue of the entire record not being available to the reviewer. Explain that to me because Steve also referred to that. That's a moot issue because it wasn't in front of the folks allocating or assigning the 5 points.
In the record, the advanced review process was explained. Now, for most of the members of the board, you don't remember how all this came up. When Florida Housing several years ago asked for principals, I think the very first RFA, 90% of the applications were found or a big number of applications were found ineligible because they didn't include principals. They didn't do it right. That's what led us to the 21 pages of instructions and the advanced review process. What the advanced review process is it gives applicants an opportunity to give Florida Housing, before the application deadline, an opportunity to turn in a draft principal disclosure form. What does that draft principal disclosure form do? What it does is it gives Florida Housing an opportunity to look at the entity, whether it's a corporation, an LLC, a partnership, and based on what is designated as the entity, it can then see if the correct principals are listed. For example, a corporation will have, officers and directors. Now, if you turned in a principal disclosure form that had something other than that for a corporation, Florida Housing would then give you that form back to say, wait a minute, you don't have the right format here. It does not get into the validity or the veracity of the information provided. It just is looking at the correct format. So here, all you turn in is a draft in the advanced review process. All you do is turn in a draft principal disclosure form. You don't turn in all the information that was found in attachment 3 of the Las Brisas application. So this reviewer, when stamping approved, never saw that. So wouldn't have known that these principals have multiple roles, would have never known that. So that's the distinction, and that's what Mr. Moore is saying. You can't after the fact look elsewhere in the application when that information wasn't available to get the 5 points. That's what's important about the RFA. You get the 5 points if your principal disclosure form is correct as of the application deadline. You don't get to decide if it's correct after the application deadline. It had to have been correct before. Our argument is it wasn't correct when it was turned in. So therefore, it wasn't correct as of the application deadline.
Okay,
May I have a brief moment to respond?
yes, please.
The
You want- yeah,
continuous
give her a
advance,
mic.
oh, thank you. I usually don't need a microphone, but thank you. The continuous advance review process is a separate process from any RFA. It is not tied to any RFA. It is a courtesy process that Florida Housing engages in to assist applicants in filling out their principal disclosure form regarding the types of principals we would expect to see for the entities that are being disclosed. No points are awarded during the continuous advance review process. The only time an applicant can achieve points in its application is during the scoring of the application. You have to have the application to score it. A point item is you can receive 5 points if your application went through that advance review process and was approved for the type of funding that you're requesting in that RFA and is still correct as of the application deadline. And the correctness goes to the disclosure of your principals. You properly disclosed all of your principals. The Blue Broadway case and HTG Village View were about applicants who omitted principals. They failed to disclose all of their principals required by rule. Those applicants were found ineligible. This is not the case we have in front of you. All principals were disclosed in the Las Brisas application. None were omitted. Florida Housing had all the information necessary to score and rank the Las Brisas application, and it was contained within the application at the time those 5 points were awarded.
I do have a follow-up, but you said they get 5 points if they do the pre-screening submittal. You said that, correct?
And yes, there's 2 requirements. They have to submit it through the continuous advance review process, and it has to be approved for the type of funding being awarded, and the principal disclosure is still correct. So you could theoretically go through advance review a year prior, and if your principals are still the same, you can submit that principal disclosure form that's stamped correct from last year, as long as those principals are still all of your principals and correct.
So there's no requirement that initial form, that initial submittal be correct? I mean, what if people have completely incorrect information on it, they get 5 points anyway?
So the 5 points are
Let's say they
set.
correct after the fact, but initially, it was not complete. Do they still get the 5 points just because they met the deadline? I guess is my question.
And I'm going to try to understand your question, so help me if I'm not answering it correctly, please let me know. So the advance review process, we don't know when it's being submitted. The form is just submitted. Florida Housing's not requiring you to submit your bylaws that show who your principals are. We're not requiring you to submit anything that you've submitted to the Department of State that shows who your principals actually are. All we're reviewing in that advance review process are the types of entities that you're disclosing. So for a corporation, we would expect to see shareholders, directors, and officers. And so if, for instance, you're disclosing a member or a manager for a corporation, that would be something in advance review that we would be like, wait, this isn't done according to rule, because the rule definition of a principal is organized by the type of entity. So we give you who we would expect to see your principals are for a corporation, for a limited liability company, et cetera.
Okay,
Does
but
that help?
my question is this, we're talking about 2 5-point systems here, not the same one. I'm talking about you get 5 points if you submit your principles, correct? Overall. in the application. You get 5 points by correctly meeting that requirement, correct?
No.
No, okay, so what are the 5 points exactly based on is my question.
And maybe I can direct you to the recommended order where I think it might lay it out, the exact requirements, so that there's no confusion. So it's the principal disclosure, it's an eligibility requirement. If you don't submit a principal disclosure form, you're not going to be considered eligible. If you don't disclose all your principals, you're not considered eligible. Let me get there. And the eligibility requirement is discussed on page 14 in paragraph 24 of the recommended order. And let me get to the point item is discussed in the recommended order on page 16 in paragraph 28. And that point item is the 5 points for the RFA. And that A and B, so you could get it, so again, page 16, paragraph 28, that's talking about stamped approved during advance review, and then subsection A, it is still correct as of application deadline, and B, it was approved for the type of funding being requested. Those are the requirements to get the 5 points.
While that's being read, there was no omission of the principles in the submission form. Everybody was accounted for per the rule. And what you are stating here in terms of the clause that said may and not must is not a scoring is not a scoring item. Is that correct? I'm asking the attorney.
The scoring item is the 5 points for the principal disclosure form. And that guidance, that the may versus must, is guidance. It's a frequently asked questions that Florida Housing has issued to help applicants in filling out their principal disclosure form. That's where it says that you may disclose them in the parenthetical.
Right.
But it doesn't say you must disclose them that way.
Okay.
And the administrative law judge listened to the testimony regarding this issue, and he found the testimony from Florida Housing to be persuasive and credible regarding the point item.
Okay,
Thank
thank
you.
you. Other questions from the board? Any other comments?
Mr. Chair,
Yes.
it was not my desire to come and say anything in front of you this morning. It was
Yeah,
an
I understand.
unnamed board
I understand.
member who
We
made me
appreciate
come
your
up here.
input. We do appreciate your input. Yes, sir.
Just for 5 seconds. The purpose of the principal disclosure form is to find out who you're doing business with, to find out if they're bad guys, to find out if you shouldn't do business with them. Every single individual that you need to know about was contained in the Las Brisas application. Their roles were also identified. In fact, on cross-examination, Ambar's witness said she only discovered they had multiple roles by looking at the actual application. There was no competitive advantage. We urge you to deny the exception.
Thank you.
Mr. Chair,
Yes,
can I just have one short comment? Here's the problem. The problem is the principal disclosure form in this advance review and the 5 points. What Florida Housing and Las Brisas want to do is put those two things together. Those are two different things. What would happen if somebody did not disclose all their principals? They would be ineligible. What happens if they don't do the form correctly? They would still be eligible, they just wouldn't be entitled to the 5 points, which is what we've argued. You can't put those two things together, they are two separate things. The advanced review process says you get those 5 points if, and this is what's in the RFA, your principal disclosure form is correct as of the application deadline. That means something. That means that you must have done something before the application deadline, i.e. go through the advanced review process. So to now say, oh, ignore that deadline, we're going to go see if we can find the information someplace else in the application after the application deadline. I just think that's the confusion here. It is two separate things, and it's not two separate things because I argue it's two separate things. It's two separate things in your RFA. It's two separate processes. We're not arguing that Las Brisas isn't eligible because correctly, we've not argued that they didn't include all their principals. But it's two steps. To get the 5 points, you needed to have a correct principal disclosure form, and our argument is they did not.
Okay, thank you. All right, I think we've heard a lot of information. So, are there any other board questions? Okay. Hearing none, we do have a motion and a second. All in favor of the motion, say aye. Aye.
Aye.
Any opposed? Thank you.
Thank you.
Thank you.
All right. Next item.
All right, item B on the legal action agenda is the matter of Marika Toltz versus Florida Housing, case number 2018-083-HHF. In February of 2017, Marika Toltz applied for funds under the Hardest Hit Fund Elderly Mortgage Assistance Program, or ELMOR. In May of that year, her application was denied on the grounds of not having a qualifying hardship, having a disqualifying criminal conviction, and she was not residing in her primary residence because she was incarcerated. She reapplied, assuming after she got out of incarceration, in November 2018, and that December was again denied. This time, the main basis was her prior felony conviction. Toltz protested this decision, and her petition was forwarded to the Division of Administrative Hearings, where a hearing was conducted. A convicted applicant can be excluded from federal programs like HHF under the Dodd-Frank Act for, among other things, committing a crime related to a mortgage or real estate transaction. Ms. Toltz was convicted in Broward County in 2011 of first-degree grand theft. She was also convicted in federal court of conspiracy to commit wire fraud. In that case, Toltz admitted to fraud related to real property transactions. This case went to hearing on the issue of whether Florida Housing correctly denied her ELMOR application. Specifically, Ms. Toltz argued that her convictions did not fall under the Dodd-Frank standards because her wire fraud was not in connection with a real estate transaction. In late April, the judge issued a recommended order finding that Florida Housing properly denied the Toltz application. No exceptions have been filed in this case. Staff recommendation is that the board adopt the findings of fact and conclusions of law and the recommendation of the recommended order without changes and issue a final order accordingly.
Thank you. Do I have a motion?
I'll move it.
Second.
Okay, motion is second. Is there anyone here that wants to speak to this? Anyone else? Okay, any questions from the board? Seeing none, all in favor?
Aye.
Any opposed? Okay.
Thank you. The next item, item C on the agenda, I would first like to thank the board for accepting this as a rather substantial supplemental item, but this will enable us to not only resolve a substantial amount of the litigation for this year, but also to move a substantial amount of funds out to where they're needed. This is a rather complicated collection of cases. Some of them were officially consolidated, others combined at the staff level so that we could deal with all of them under the same RFA. I discussed with the chair just before the meeting that I think it would be a good idea to break this into three parts and have three motions on it. And I think I will do that, if it's all right with you guys, and stop for a motion and a vote at the appropriate places.
Yeah, that's fine. Go ahead.
This is the matters of Durham Place, Amelia Court, HTG Banyan, and Blue Pinellas versus Florida Housing, case numbers 2019-012 BP, 019 BP, 016 BP, and 015 BP, and numerous interveners are listed in your materials. These cases all arise from RFA 2018-112, which is the housing credit RFA for the 6 largest counties outside Miami-Dade. In February, the corporation issued its preliminary scoring and ranking for this RFA, awarding funding to several applicants, including Hawthorne Park is the only one from Orange County, HTG Heron Estates is the only one from Palm Beach, and The Shores is the only ones from Pinellas. These were not the only funded applications, but the ones that are relevant here. The 4 petitioners in this case were all eligible, but were not funded due to their position in the final rankings. The petitions were referred to the Division of Administrative Hearings. Eventually, all the challenges to competing apps were dropped except two, and that is Amelia Court's challenge to Hawthorne Park and Durham Place's challenge to Amelia Court. These two cases were consolidated together, and we'll deal with the other cases that you see listed later on. Regarding the Amelia Court matter, the specific issue for the board to consider today, besides the recommended order, of course, but within that order, the issues are for Hawthorne Place and Amelia. The validity of Hawthorne Park's local government contribution form was challenged by Amelia Court on the grounds that Amelia Court had obtained a temporary injunction against Orange County against providing some funding to Hawthorne Park. Amelia Court argued that this prevented Hawthorne Park from getting the funding, and therefore they should be ineligible. Conversely, Durham Place challenged the local government contribution form submitted by Amelia Court. Durham also challenged Amelia's disclosure of developer principles. Just to clarify, in terms of the potential results of these disputes, if Hawthorne Park is deemed ineligible, then Amelia Court would be selected for funding. If both Hawthorne and Amelia are found ineligible, then Durham Place would be funded. And that's why Durham Place is in the case, I guess. A hearing was held this April, after which the ALJ issued a recommended order upholding Florida Housing's original scoring of the Hawthorne application was correct, and recommended that the Amelia and Durham petitions both be dismissed. Staff recommendation on that case. Find it, please. Sorry, 1 second, please. Is to adopt the recommended order, the findings of fact of the recommended order, and the conclusions of law of the recommended order as your final order, and issue that accordingly. Exceptions were filed, and parties are here to address the board.
Okay. Please come forward and state your name, organization you're with.
Good morning. I'm Chris Bryant. I represent Amelia Court at Creative Village.
Okay. Did we get a motion for?
So move.
Oh, sorry. We have a motion.
So move.
Second.
A motion is second. Now
Discussion and, okay.
Thank you. Keep me straight here.
Thanks.
Okay.
Thank you, Warren.
Again, for the record, Chris Bryant for Amelia Court at Creative Village. I'll be very brief. We have filed written exceptions to the recommended order, and as I noted in the exceptions that we filed, the case law has stated that the filing of exceptions is necessary to preserve any issues for appeal, and I think your counsel would probably agree that that's what the case law says. So
Yeah.
So I do not intend to spend time this morning drilling down and further arguing whether we're right or not on the exceptions. Certainly some of, we don't agree, of course, or we wouldn't have filed exceptions, but some of these in the unique posture that this case comes forward with, such as the issuance of the temporary injunction and the meaning of that temporary injunction are, I know one of the issues your counsel have raised in responding to exceptions is that's not something that you should be reviewing. You don't have substantive jurisdiction over that. I'm not sure I'll concede that as I sit here now, but it's a pretty good argument. It probably is going to be appropriate for an appellate court to make that determination. So we won't add further comment to our written exceptions.
Thank you, sir. Okay, next.
Obviously, I'll make this short since counsel made his short as well. If you look at the recommended order. Oh, I'm sorry. My name is Doug Manson. I'm here for Hawthorne Park. And I just said there's been extensive proceedings before this. Obviously, you heard about the motion the temporary injunction order. We also had an administrative law judge obviously go through and not only do a one-day hearing on it, but have to review many tens of pages of motions that were filed beforehand, and then, of course, the proposed recommended orders filed by all parties. And after consideration of that, he made a determination based on legal issues, not based on issues that have to deal with affordable housing, that the temporary injunction does not preclude any activity by Florida Housing Finance Corporation or by the administrative law judge. And so therefore, my client's form was still valid at this point in time to be reviewed, and it's still appropriate for you to be able to award tax credits as you initially determined. I was just going to point out one part of the administrative judge's recommended order that I think encapsulates the issue. And he's citing in portions of this to the temporary injunction, just one paragraph. Furthermore, by the circuit court's express terms, the temporary injunction does not prevent, quote, any activity of Florida Housing, including an award of tax credits to Hawthorne Park. In paren, neither does the temporary injunction inhibit the actions of the administrative law judge in this matter. The temporary injunction only controls the actions of Orange County at Wendover/Hawthorne Park, pending a final adjudication and granting of permanent relief. And so there is another proceeding to be held before it's final. The temporary injunction was taken on appeal, which is also discussed in the recommended order. Even after that, it would then go back to the circuit judge, and another hearing would be held for a final adjudication. And then furthermore, I'll point out one thing that does limit your review of conclusions of law of a judge in this case, and that's section 12057, paren 1, paren L. And it says that the agency may adopt recommended order as a final order of the agency. The agency in its final order may reject or modify the conclusions of law, they emphasize this section, over which it has substantive jurisdiction. And in this case, this is a legal issue. It's not an issue in which you all have any particular expertise. It's not an affordable housing issue. And the exceptions, the response to the exceptions, rather, discuss the case law that says what limits your authority to look over or, say, overturn legal conclusions. And the case that I choose to cite is the Deep Lagoon Boat Club, LTD versus Sheridan. It's 784 Southern 2nd, 1140. And it was a similar issue. That's why I bring it up. And in this case, our opponents are arguing that temporary injunction should somehow be collateral estoppel. In other words, it would legally stop this issue from being tried in the administrative proceeding. That's inappropriate because this is a temporary achievement. It's not a final determination. In that case, the Secretary of DEP recognized he didn't have authority to review the ALJ's decision to refuse to apply the principle of collateral estoppel and res judicata in that case. The court in the second DCA found the Secretary correctly determined that he didn't have authority in the case. Although the Secretary possesses many powers in conjunction with the exercise of the Department's substantive jurisdiction, the power to reverse an ALJ's decision not to apply collateral estoppel is not one of them. And that's a common theme in a number of cases that were cited. You know, within your area of affordable housing, financial determinations, your rules and regulations, you have the clear authority to make determinations on that. The administrative law judge's clear authority is through issues like evidentiary determinations, issues like legal issues on whether or not collateral estoppel or res judicata apply. And in this case, his decision was that the temporary injunction did not affect the case. All right. Thank you for your time.
Thank you. Mr. McGuire?
Good morning, Chris McGuire, Florida Housing. I don't have a lot to add to that. Happy to answer any of your questions, but you know, our position from day one on this was that the decision as to whether the Orange County did or didn't have authority to commit SHIP funds was one for the circuit court. It's not one for us to decide in this case. And we would be bound by whatever final decision came out of the circuit court. We don't think that there's a final decision out of the circuit court, so at this point, as far as we're concerned, the application is still valid and still eligible and should still be funded. If the circuit court comes up with a final determination later, we'll figure that out then, but it's not part of this litigation. So I think that you should just accept the recommended order as it is.
Thank you. Any other comments? Any questions on this from the board? Seeing none, we have a motion and a second. All in favor? Aye. Any opposed? Thank you.
Thank you.
All right, number 2.
I have pages and pages of information I could be giving you on this if you had questions for me.
We were given pages and pages yesterday, as a matter of fact.
It's a rather thick packet, yes. Also in that packet of pages is the next set of cases in between HTG Heron Estates and HTG Banyan. The issues here were again on the issues of local government contributions. After some discussion, staff agreed with HTG Banyan that HTG Heron should not be recommended for funding. To that end, we've entered into a stipulation with them. HTG, Banyan, Heron, and Florida Housing have all agreed with the result in this case, and Banyan has voluntarily dropped his case as a result. The staff recommendation for this case is that you issue a final order adopting the stipulation and funding HTG Banyan instead of HTG Heron Estates.
Motion to approve staff recommendation.
Second.
All right, great, we have a motion and a second. Any discussion? Anyone else want to speak to this? Seeing none, all in favor? Aye. Any opposed? Okay, number 3.
The last set of cases under this RFA involve Blue Pinellas and the Shores. Blue Pinellas challenged the Shores regarding its proximity scoring to a public school and medical facility. After some discovery, it was established that the proximity scoring of the Shores was in fact incorrect. As a result, Florida Housing changed its position. All the parties have agreed and stipulated that the Shores is ineligible and that Blue Pinellas should be selected for funding. And so staff recommendation in this case is that that you issue a final order adopting the stipulation and finding that Blue Pinellas would be awarded funding instead of the Shores.
Motion to approve staff recommendation.
Second.
We have a motion and a second. Is anyone, any questions for staff? Anyone here to speak to this? Seeing none, all in favor? Aye. Any opposed? Before we leave this one, Hugh, you know, I kind of think I'm a positive person, and when I get something like this, the good thing is I learn a new word every time. Estoppel, I had no idea what that was, so I looked it up to figure out what it was. So I appreciate the new word every once in a while.
Okay. We do what we can. The next item on the agenda, item D, is the case of MHP Jordan Bayou versus Florida Housing, case number 2019-050BP. This case arises from RFA 2019-109, that is home financing for Hurricane Michael affected communities and also for general rural development. The board previously selected 6 applications for funding under this RFA and also authorized additional home funding that was available at the time to fund another eligible application for a total of 7. Jordan Bayou, 50-unit development in Franklin County, unfortunately was not selected for funding, and due to it not completing the unit mix chart in the application, and they have filed a protest. After some review and discussion, staff has reconsidered its position and believes Jordan Park should be eligible for funding, as all the information for that chart was found, this may sound familiar, elsewhere in the application. To that end, we have entered into a consent agreement. This is actually going to be 2 motions, sorry, that we would like you to adopt as a final order, adopting the findings of fact and the conclusions of law and the recommendation of the consent agreement as your final order and issuing it, and finding that Jordan Park be funded. That is the first motion I would like you to consider.
Okay, do I have
Second.
a motion and a second. Any discussion or questions? Seeing none, all in favor? Aye. Any opposed? Okay.
Now, the second request I have in motion I would like you to consider is a little bit different. Staff also recommends that the board authorize us to use the additional home allocation to fund all remaining Tier 1 applications in this RFA. Since this RFA was issued and scored, we have received confirmation of our 2019 home allocation. Now that we know the total amount, there is enough home funding to fund not only Jordan Park, but all the eligible unfunded Tier 1 applications in this RFA. Tier 1 is distinguished by being those that are for Hurricane Michael relief. So we would like you to authorize us to use our, I guess, newly authorized additional home funding to fund all of those applications that are eligible in Tier 1.
So, second.
I have a motion and a second. Any discussion? Seeing none, all in favor? Aye. Any opposed? I will just say, okay, the ball's now in you developers' court. We got the money, now we need you to build the units without extensions and delays and rule waivers. So, thank you. Okay, multifamily programs. Jesse? Welcome to your second board meeting.
I made it back. Good morning. Jesse Leon, Director of Multifamily Programs for Florida Housing. In your packet, you have multifamily programs, action items A and B. The applicant's Bessie Dix Residential Community Group Home, RFA 2014-395G, and Flora Residential Community Group Home, RFA 2014-396G, have complied with all requests for information. We received what we needed and are comfortable with moving forward, and the recommendation is staff recommends to approve and direct the applicant staff and Amerinet to proceed with an update to the credit underwriting report.
Okay, we'll take them one at a time as far as the motion, I believe. So we need to do them one at a time.
So moved.
Okay,
Second.
a motion and a second. Any discussion? Okay, all in favor? Aye. Any opposed? Okay, now go ahead and do the one for action item B.
Flora.
Staff recommends to approve and direct the applicant staff and Amerinet to proceed with an update to the credit underwriting report for RFA 2014-396G, Flora Residential Community Group Home.
Okay, thank you. Do I have a motion?
So moved.
Second.
I have a motion and a second. All in favor?
Aye.
Aye.
Great. Thank you. Appreciate y'all getting that done between the last meeting and now. Marissa,
Good
hopefully
morning,
you're
everyone.
feeling
Good
better
morning.
today.
I am, thank you. We'll start with the first item for multifamily allocations. This is RFA 2019-108, sale financing for farm worker and commercial fishing worker housing. On April 11th, 2019, Florida Housing issued RFA 2019-108, offering $5,510,000 of sale funding to applicants proposing the new construction or rehabilitation of commercial fishing worker or farm worker developments. The deadline for receipt of applications was May 7th, 2019. We received one application in response to this RFA. The review committee members were assigned and designated by our executive director, and each review committee member scored their assigned portions of the submitted application. At the June 4th, 2019 review committee meeting, the committee members presented their scores, and the committee carried out the funding selection process in accordance with the RFA. And the 2019-108 all applications chart that you have in Exhibit A lists the scored application. And the review committee considered the following motions. A motion for the review committee to accept the scoring results set out on Exhibit A. And you will know in Exhibit A that that one application that was submitted was deemed ineligible for funding. And then the review committee also considered a motion to recommend to the board that you adopt the scoring results that were set out on Exhibit A and find that application ineligible for funding. And those motions passed unanimously. And so what I anticipate you may all be wondering, this one application, ineligible, you have this funding pot, what's going on here? And the application was deemed ineligible because it selected an ineligible development type. It selected townhomes, and those were not eligible for this RFA. And so while we have to hold the line across the line no matter how many applications are submitted per RFA, and so we do not recommend that the board consider making this application eligible or doing a conditional recommendation that they do the right thing, because what happens is in those RFAs where we get numerous applications, we can't be doing the same thing. We sort of have to have fidelity to the process. So unfortunately, we are recommending, as I said, that you adopt the scoring recommendations and the application be deemed ineligible. What still happens is there is a notice of protest process, so you see that in the board write-up as well. They still have the opportunity to challenge that scoring recommendation, and that process would play out as it would in any other RFA, and we could come back with a recommendation from an ALJ or something like that if they were successful at DOE and if they chose to challenge. But that's just a little bit more of the background I wanted to give you before making the actual recommendation to you that you approve the committee's recommendations that the board adopt the scoring results set out on Exhibit A. And then the unallocated balance of the just over 5.5 million remaining, as in the RFA, it states any remaining funding will be distributed as approved by the board. We recommend that goes back into the sale pot. It's been offered as farm fish. It'll go back into the larger sale pot moving forward. And then, like I said before, if there's a notice of intent to protest or formal written protest that results in hearing, that we come back with any recommended order for your consideration. Thank you.
I'd like to make a motion for staff recommendation on items A, B, and C.
Okay, we have a motion. Do we have a second?
Second.
All right, we have a motion in a couple of seconds. Any discussion or questions for Marissa? Seeing none, all in favor?
Aye.
Any opposed? Okay.
Thank you. So item number 2, we have the 2019-2020 timeline and tentative funding amounts for RFAs for our upcoming RFA cycle. So I provided a little supplemental timeline at your chairs that you have. The timeline that you had in your materials didn't have the actual anticipated, and again, tentative funding amounts attached yet. But this sort of follows the fiscal presentation that Angie did earlier. This is how you see the splits come out. So we've been working hard in planning our 2019-2020 RFA funding cycle. We've held 2 large RFA workshops, one in April and one just a few weeks ago in June, to solicit stakeholder feedback on our process. And so what you're seeing here is the tentative timeline as we move forward with the RFA cycle. So the corporation expects to offer the following funding through various RFAs. The estimated $101,821,000 in sale program funding. And again, as Angie mentioned and you all approved, that item is through the 2019 appropriation plus the unrestricted net position, any other sale program income we have to build that number. And then because we didn't have proviso for a workforce RFA, we're also asking you to look at that then estimated $19 million in sale workforce funding, and that's $4 million from last year's legislative appropriation that was left over, with the additional $15 million you've approved from unrestricted net position for that RFA. We have the estimated $5 million in the rental recovery loan program, RRLP funding, for which we're having a workshop next week. And then we also have an estimated just over $6.9 million in National Housing Trust Fund funding. And to remind you, that's federal funding, deep targeting. We apply that with our sale funding. So that pairs with our sale RFA for family elderly. And then we have an estimated $5.9 million in housing credit allocation. And so all of that will be split according to our legislative requirements for the demographic splits and the geographic splits, which we've presented to you previously, and that's what you see on the sample timeline. So that's what we have here for your consideration, and we're asking you to authorize us to proceed with the development of these RFAs for sale, housing credit, and RRLP funding, and authorize the executive director to establish review committees for our RFAs as each RFA is issued, to make recommendations for award for the board. Thank you.
Thank you. Do I have a motion?
So moved.
Second.
I have a motion and a second. Discussion? Questions for staff? Okay, seeing none, all in favor?
Aye.
Aye.
Any opposed? Okay, thank you.
Thank you. Turn over to Nancy.
Hello again.
Hello.
So at our last board meeting in May, the board approved the allocation split for the State Department Incentive Loan Program for the next 3 years. After the meeting, staff realized that the geographic split provided to the board for its approval was wrong. It was a scrivener's error. So I'm back to you today to get approval for the correct split. So just as a reminder, the state calls for at least 10% of program funds to be made available each year across the 3 county categories of large, medium, and small. Because the small county category shows an actual need percentage of 3.1%, that is less than the 10% minimum required by statute. So we increased the small county category up to 10%, and this amount was deducted per statute from the category with the highest percentage, the large county category. So Now we're recommending to you the correct amount. Based on the 2019 study, the proposed allocation of resources for the SAIL program between the large, medium, and small counties during 2019, 2020, and 2021 is as follows. Large counties, 53.8%, medium counties, 36.2%, and small counties, 10%.
Motion to approve?
Second.
All right, we have a motion and a second. Any other discussion? Any questions? All right. All in favor?
Aye.
Any opposed?
Thank you.
You're still up.
Still up. This is professional services selection. In particular, this is the single source procurement for the Affordable Housing Catalyst program. And this program is authorized by Section 420, 531 of the Florida statutes. So this is our training and technical assistance program for local governments and community-based organizations on state and federal programs. Section 420.531 specifies that to the maximum extent feasible, we use a nonprofit organization, and it says that that organization must have as its primary mission the provision of affordable housing training and technical assistance, an ability to provide that training and TA statewide, and a proven track record of successfully providing that training and TA under the Affordable Housing Catalyst program. The only firm that meets all of these requirements is the Florida Housing Coalition. Rule 67-49.0032 of the code allows the board to exempt contractual services from competitive solicitation requirements upon a determination by the executive director that such services are most readily available from a single source. And in this case, our executive director has made this determination. The current contract for these services with the Florida Housing Coalition expires at the end of this month. Florida Housing has a continuing need for these services, and the legislature has appropriated funding for this program for the next fiscal year. So today, we're asking that you authorize staff to enter into a one-year single-source contract with the Florida Housing Coalition to deliver affordable housing training and technical assistance under the Catalyst program, subject to funding availability.
Okay, do I have a motion?
So moved.
Second? Do I have a second?
Second.
All right, we have a motion and a second. Any discussion? So Florida Housing Coalition is a nonprofit?
Yes,
Are
sir.
they a 501c3 or
Yes,
are
sir.
they a C something else?
C3.
Okay, great. All right. Any other questions? Seeing none, all in favor? Aye. Any opposed? Good.
Thank you.
Thank you.
Good morning again.
Good morning.
This is not litigation.
Oh, shucks.
Item B on the action agenda for professional services selection is the contract renewal for insurance agent of record. In December 2014, Florida Housing entered into a 5-year contract with Rogers Gunter Vaughn Insurance, or RGVI, to serve as the corporation's insurance agent of record for corporate insurance. They maintain our annual policies for commercial general liability, crime, business owners, et cetera. The original term of this contract is set to expire this December, and we do have a 5-year renewal option. Florida staff supports the renewal for the 5-year contract period, and that is what that's our staff recommendation, is to ask you to authorize us to renew the contract for another 5 years.
Okay, thank you. Do I have a motion?
So moved.
Do I have a second?
Second.
All right, motion and a second. Any discussion, any questions? Seeing none, all in favor?
I have
Oh,
one.
we have one? Speak up. Go ahead.
So, I mean, what's kind of the process that, drew you to the conclusion to renew the 5-year contract? I mean, do you go out and speak to any other agencies to see if there's any other benefit to the corporation, or?
Yeah. I am not the contract manager for that, so I am not sure. I would probably have to ask Angie. There she is. I'd like to call a friend.
You do need a lifeline once in a while.
I need a lifeline.
So for the renewal, no, we did not go out and speak to any other insurance agents at this point, but during the RFA process, obviously, we had multiple applicants, and RGVI is the one that was, that came out ahead. And RGVI, they're doing great under the contract. You know, we've been completely satisfied with their performance, and they will go out and competitively bid more insurance, so.
I'm just happy with them. Okay.
It was competitively bid
Yes.
originally.
Originally?
Yeah.
Yes.
5 years ago.
5 years.
Right, okay.
Nothing's changed in 5 years. Okay. Any other questions? Let me look and make sure I should. Okay. I do not see any other questions. All in favor? Aye. Any opposed?
Aye.
Everyone was an aye?
Yeah.
Okay. All right, very good. Thank you.
Thank you.
All right. And we already did the next item in your package, so that was covered earlier. Now we're at the consent agenda. There were no items pulled from the consent agenda previously, so do I have a motion to approve consent agenda?
So moved.
Second.
I have a motion and a second. All in favor?
Aye.
Any opposed? Seeing none, consent agenda are approved. All right, now's the time for other public comment. If anyone would like to speak, make your way to the mic. We have several. And I would ask you to state your name and if you're with an organization, what organization. 5 minutes, please. Yeah, go ahead.
5 minutes. Good morning.
Morning.
My name is Taria Robinson. I am the Director of Development for Age and Truth Community Senior Services here in Jacksonville, Florida. I greet you on behalf of our CEO and President Teresa Barton, who was unable to attend. I wanted to take this opportunity today to address the committee to say thank you all so much for your support and continued backing for our affordable senior housing properties located here in downtown Jacksonville. We are the owner of the Cathedral Residences. That's the Cathedral Towers, Terrace, and Townhouse, as well as a low-rise that provides affordable housing for individuals with disabilities. We do this in partnership with Blue Sky Communities and Carteret Management, who provides the day-to-day oversight and operations for those properties. Cathedral Foundation, who is our parent corporation, has provided affordable housing for seniors for over 50 years here in Jacksonville. And we are so thankful for your support that we have been able to do complete renovations of 2 of our properties, our Cathedral Terrace and our Cathedral Towers, and we will begin complete renovations of our Cathedral Townhouse this fall, as well as prepare to new constructions for our Ashley Square. And that's all due to your support and financing. So wanted to take this opportunity today to say thank you so much.
Thank you. Thank you.
Good morning. My name is Natalie Maxwell. I'm an attorney with Florida Legal Services. I just wanted to thank the board and the staff for the continuing work on developing the preservation strategies for affordable housing throughout the state, the seriousness with which the staff is doing that. I did want to offer a comment regarding the update that was provided by staff that was in the board packet, in the informational packet. The staff had stated that the board had requested that staff research policies providing tenant protections, including acceptable notice periods for tenants before rent increases. And I just wanted to I haven't had a chance to raise it with staff, but it is something that has been raised by affordable housing advocates through public comments over the last several years. And that is in the 2009 compliance manual for tax credit properties. There's a provision that provides for rent increases during the term of the lease when there is an adjustment made by HUD in the fair market rents. And so that continues to be a problem. I know that there recently were some tenants that contacted the local legal aid program here in Jacksonville because of a rent increase that was occurring during the term of the lease. And obviously for low-income folks who have very restricted budgets, those types of unexpected increases can send people into homelessness. So I just want to raise that with the board, and one of my colleagues from Jacksonville Area Legal Aid was planning to submit some comments just to provide some examples of where this is happening. I don't know if the staff or board has looked at this issue more specifically, but I did want to bring it to your attention. Thank you.
Okay, thank you, and appreciate you working with staff and providing information and sources of information. That helps. Yes, sir.
Good morning, Mr. Chair and Board. Sean Wilson, Blue Sky Communities, and I'm also the chair of the Coalition of Affordable Housing Providers. And want to echo Ms. Robinson's sentiments. We really are making a big impact in the Cathedral District here in downtown Jacksonville, which is just a couple of blocks away, along with a fabulous nonprofit partner, Aging True. Now putting on my hat as chair of the Coalition of Affordable Housing Providers, must thank staff for being creative and generous, and for board going along with the additional funding for the SAIL program. As I always say, the SAIL program is the key to unlocking the door where all those 4% credits are just sitting, because you guys can't allocate the 4% credits unless you can make the numbers work, and the only way to make the numbers work is with SAIL. Thank you again, and we're really looking forward to presenting some great applications in the SAIL program coming up this fall. Thank you very much.
Okay, thank you.
Thank you, Sean.
All right, seeing no one else, I would like to just make a comment that yesterday, several of us got to tour several facilities here in Jacksonville, Vescor properties, and I tell you, it is amazing what affordable housing looks like today compared to previous, well, long time ago. It's been that way for a couple of years. It does look great. What we saw just amazed me. I just wish a number of elected officials from the Panhandle could tour the facilities we toured yesterday. So thank you to Vescor for hosting us at a couple of their properties, and we'll be doing this, I hope, in a couple other cities. Maybe we can do one in Tampa when we go down there in a while. I forget what month it is.
That's
but-
August, yeah.
Is it August?
The next board meeting is August 2nd.
Okay, so August 2nd.
And then Mr. Chairman, we'll be in the Florida Keys in Islamorada on September 20th, and hope to see a lot of the good work that we've done. We've got over 300 units in the pipeline in the Florida Keys, which was, of course, hit by Hurricane Irma, and look forward to seeing the progress down there in South Florida.
Yes, I certainly do. That will be a unique location for us to get to, so, especially if you live in the Panhandle. It's only about 700 miles, so that's not too bad.
Very broad and diverse state.
Yeah, very, very broad and diverse, that's right.
Mr. Chair,
Yes.
you can thank me for that. Last year, I spoke to Trey when he first came on board and said we really needed to have a meeting down there. So I apologize for that, but I want to thank Trey for arranging that and setting it up.
Well, thank you for doing that. I spoke to him about having one in the Panhandle last year, and you saw what happened there, so let's hope you have not put a curse on Monroe County. So anyways, all right. Any other board comments? Anybody like to make any comments? I thank the board for attending, and thank the staff for all the work you do. It never ceases to amaze me how much you can do and how much legal can send me the day before the meeting. So anyways, thank you. And where's Mr. Ozark sitting? Yeah, okay, he's back there in the back. We've got a new nickname for him. It's Ozark. So, all right. With that, if there's nothing else, meeting is adjourned.
All right. Thank you, sir. Good meeting, actually. Hour and a half.
Yeah.
It's pretty good. It was better than I expected.
Thank you.